Good afternoon. My name is Brady Mills. I'm from the law firm of Morris, Manning & Martin. My law firm focuses almost exclusively on unfair trade investigations, primarily anti-dumping and countervailing duty investigations. Personally, I focus in the past few years, I've become sort of a specialist in countervailing duty investigations. This has sort of become necessary because there's been so many countervailing duty cases filed in the last few years, particularly against Korea. So I've been involved in most of the CVD investigations involving Korea over the last several years, including line pipe, the corrosion-resistant case, the nose investigation, cold-rolled, hot-rolled. So I've kind of been on the front lines of a lot of the countervailing duty investigations involving Korea recently. So with that background, I really appreciate the opportunity here to talk to you about some recent trends that I've seen in countervailing duty investigations. Unfortunately, these trends are not positive. In fact, they're very negative, and these changes are not designed to increase transparency or to calculate more accurate margins. As far as I can tell, they're only designed for one purpose, and that's to increase countervailing duty margins, period. Commerce has really taken a very aggressive approach in recent investigations, particularly the flat-rolled investigations that just finished up this year. And so the best way to deal with these recent trends is to fully understand what these trends are and to try to take steps to try to mitigate the risks that are associated with these new trends. So the three trends that I want to talk about today, the first trend is commerce's aggressive use of punitive adverse facts available in response to the new changes in the law that Robert talked about a few moments ago. The second trend is commerce's increased focus on requiring companies to voluntarily disclose any other forms of assistance they might have received from the government. And that includes assistance that's not even a program that's been alleged in the petition or that's even included in the questionnaire. And so basically it's a very broad question that requires companies to report any kind of assistance. The third trend is commerce's strict enforcement of its new factual regulations and the limitations that this imposes on companies' ability to actually correct errors or to submit new factual information to try to correct the record. Before getting into each of these new trends, I just want to briefly give a little background on facts available and adverse facts available for those who aren't familiar with these concepts, because it's sort of central to what I'm going to be talking about. So under U.S. law, commerce has the authority, and in fact they're required to use what's called facts available to fill gaps in the factual record. So, for example, if a party participating in a case doesn't respond fully to a questionnaire, they don't provide the information in the manner and form that commerce requests it, or if they provide information that cannot be verified, then commerce has to have a way to fill that factual gap in the record. And so this statutory provision is sort of a practical provision that provides commerce with the authority to sort of fill that gap in the record so that they can reach their final determination. The statute also provides commerce with the authority, well actually it provides it with the discretion, which goes on what Robert was talking about, the discretion to also apply an adverse inference when selecting among the facts available. And this is only supposed to be done when a party fails to cooperate fully by not acting to the best of their ability. And so that's just a background on what facts available and adverse facts available are. Okay, so the first trend is commerce's aggressive use of punitive adverse facts available. And a lot of this derives from the new changes in the law. And I have up here some of the provisions from the new law. But generally speaking, these provisions have provided commerce with much broader discretion in selecting what adverse facts available rate to use. It sets out a hierarchy of what sources commerce can go to find adverse facts available. But it also provides commerce, if it can't find a same or similar subsidy rate from another proceeding in Korea, for example, that commerce has broad discretion to find any other rate that it considers reasonable. And so it's a very broad grant of discretion for commerce in selecting the adverse facts available rates. The statute is also amended to give commerce discretion to actually apply. It specifically instructs commerce that they can apply the highest adverse facts available rate from another proceeding. So, for example, if commerce had investigated a program in Korea in 3 different investigations, and in one investigation it found a 1% subsidy, and another one it found a 3% subsidy, and then another one it found a 10% subsidy, commerce could select that 10% rate and just select the highest of the 3 rates instead of selecting something in the middle or sort of trying to find something that's more reasonable. The third, and I think most most damaging provision is this provision that provides Commerce with authority to basically select a rate that doesn't have to be realistic. It doesn't have to reflect any type of commercial reality. And this provision is particularly dangerous because it's a specific overruling of certain cases by the U.S. Court of Appeals where they had actually started to put limitations on Commerce's ability to apply punitive adverse facts available. The Court of Appeals decision actually used the terminology commercial reality, and so the statute actually used the exact language that the court had used in its decision to put limits on Commerce as basically a way of telling the courts, to butt out that this is something that you guys shouldn't be getting involved in. And so with these new provisions in hand, Commerce has been really aggressively in ramping up their use of adverse facts available. This new statute it's a message from Congress telling Commerce to get tough and to basically start using your adverse facts available authority more aggressively and to use higher and more punitive margins. Commerce has heard the message loud and clear. They've been aggressively applying adverse facts available since the effective date of the new law, which was August of 2015. And so in this slide, we did a little comparison of Commerce's use of adverse facts available in cases in the 13-month period before the new law went into effect and then the 13-month period after the new law went into effect. And as you can see, Commerce has drastically increased its use of adverse facts available. It's more than doubled its use of adverse facts available. Now, these charts reflect both anti-dumping and countervailing duty cases, but a good amount of these cases involve countervailing duty investigations. Some recent examples of Commerce using punitive adverse facts available are seen in the recent cold-rolled and hot-rolled investigations for Korea, where Commerce applied significant adverse facts available to the mandatory respondent POSCO in that investigation, and in the anti-dumping investigation for corrosion resistant, where they applied approximately a 48% adverse facts available rate to Hyundai Steel. So the second trend that I want to talk about is Commerce's increased focus on requiring companies to voluntarily disclose any other forms of assistance that they might have received from the government or be subject to potential adverse facts available. So Commerce now has included in its standard questionnaire to the government and to the responding companies a question it's very broad. It asks any company, it requires the government to report any form of assistance that was directly or indirectly provided, and it requires the company to disclose any form of assistance that it was directly or indirectly provided by the government. These questions are very broad, and they apply not only to the period of review or investigation, which usually only involves 1 calendar year, but it also stretches back for what's known as the average useful life period, which in steel cases can be as far back as 15 years. So the risks posed by these questions are very serious. Because Commerce has not defined what it means by assistance in the questionnaire, it can be interpreted very broadly to include things that a company might not consider to be a countervailable subsidy. If a company received a small grant for a child care facility or something, they might not even consider that to be considered a countervailable subsidy, and they would think reasonably that that's not something that they need to report to Commerce. And also, companies track different types of assistance in different records in their books and records, and so if a company has a lot of different accounts that it keeps different types of assistance in, it's very burdensome and sometimes almost impossible for a large company, to go through all of its accounts and identify any other form of assistance that it might have received from the government, again, because there's no definition of what assistance constitutes. The failure to report and identify these other forms of assistance in your questionnaire response can have very damaging consequences. Commerce will come to verification, and they'll go through the company's system, they'll look through their books and records, they'll look through their chart of accounts, and if they find any form of other assistance that you did not report in your questionnaire response, they won't take information about the benefit amount and sort of include it in their verification report so they can calculate an actual subsidy rate for that benefit that they discovered. They'll just make a notation of it in their verification report, and then they'll apply adverse facts available to the company. This has happened in several recent investigations. In the heavy-walled rectangular pipe and tube case from Turkey, one of the respondents at verification, it came to light that they hadn't reported some small grants, and Commerce took note of it and basically applied a 16% adverse facts available rate to a company that otherwise would have been de minimis. Also, in the super calendar paper from Canada case, Commerce was at verification, and it wasn't even the responding company. It was actually just an affiliated company of the respondent who had not reported some other form of assistance. And the amounts, I was involved in that case, not with this particular company, but the grand amounts were so small that they would have rounded to zero if Commerce would have taken information about them. But instead of doing that, Commerce just made note of it, and they applied a 17% adverse facts available rate to this company. So they basically manufactured a 17% subsidy rate out of nothing for a company that otherwise would have been de minimis and would have been actually excluded from the order. The third trend I want to talk about, it kind of goes hand in hand with the first two trends that I'm talking about, and that's Commerce's strict enforcement of its new factual regulations and the limits that they impose on a company's ability to actually correct errors and to put additional factual information on the record. These new regulations became effective in May of 2013. And what these regulations do is they come up with categories of factual information. And so, for example, they'll define one category of factual information as information submitted in response to a questionnaire or a supplemental questionnaire response. There's also another category for information, benchmark information to measure the adequacy of remuneration. And then the regulations then set out very strict deadlines for when factual information that falls within each of those categories can be submitted. And so if a company is preparing their questionnaire response and, for example, if they're preparing an initial questionnaire response and they look through their books and records and they miss some other forms of assistance that they didn't have in time to submit the questionnaire response, the factual regulations really provide no opportunity for that party, if they later discover that information, to actually do the right thing. Actually, if a company wants to come clean and say, hey, I made a mistake, we didn't find this information, the regulations no longer provide an opportunity for a party to submit that information. There's no safe harbor. So, for example, this is an example that I've faced recently where a company has done this. They submitted their questionnaire response and a supplemental questionnaire response, and then they discovered some small forms of assistance they hadn't reported. And we didn't think that they constituted a countervailable subsidy, but we're so worried about being caught at verification, not reporting something, that we wanted to disclose it. But we came to the conclusion that under Commerce's factual regulations, if we actually try to disclose this there's one catch-all provision that provides an opportunity to submit some factual information, but it's very narrow, and it basically limits you to only information that you couldn't have already submitted under any of the other categories. And so we concluded that because this other assistance was something that we could have reported in our initial questionnaire response, that there was no opportunity for us under the regulations to disclose this to Commerce. And so basically, if we were to, we felt that the risk of actually telling Commerce about this other assistance was too risky, because then we might be giving them, the analogy I use is you're basically giving Commerce a gun to shoot you with, because if you give them the factual information, you disclose it to them and say, we missed this, they can reject it as untimely, but then they have a record. They know that you got this other assistance. So then they can come at verification, then it can actually look in your accounts and find it, and then they can basically make notation of it in their report and apply adverse facts available. So the new regulations really put companies in a real bind as far as trying to report any other forms of assistance. So those are sort of three of the recent trends that I see in countervailing duty investigations and have become very real in cases that I've been involved in. So the next question is, what can you do to prepare for this? The short answer is it's very hard to prepare. As Robert said, Commerce has very great discretion here, and so if Commerce is bound and determined to apply adverse facts available against you, it's very difficult to defend yourself against that. However, there are a lot of things that you can do. One of the most important things, I think, is that you have to think about time is of the essence. Because of these factual regulations, as soon as a countervailing duty petition is filed, the companies and the government need to closely coordinate and try to come up with a coordinated approach for reporting all other forms of assistance and coming up with accurate responses, because you might not get another opportunity to make corrections later. The companies and the government and the respondents must also respond to all questions in Commerce's questionnaire. So you can't interpret the question in a way that you want to interpret it. You actually have to literally answer Commerce's question in every subpart of its questions, because if later on Commerce determines that you weren't responsive, they can use that again as a way to apply adverse facts available. Again, this kind of touches upon what I said. You need to search carefully through all your records to make sure you can identify all of the forms of assistance that you might have received, become familiar with all your accounts to see where that stuff could be kept. You should also review your record keeping and document retention practices to make sure, again, if you get in a situation where Commerce is asking you to report all of your assistance for the past 15 years, if you have a document retention policy where you destroy documents after 5 years, that can create a problem for you. And so, but if you do have that situation and you identify it early, you can actually raise it with Commerce within 14 days after the questionnaire is issued and tell them that you're having difficulty responding to a certain part of the questionnaire based on your record retention policies and things like that. The final thing that you can do to prepare, and I think is one of the most critical things, is verification, because verification is really where a lot of these problems are occurring. You need to make sure that all personnel who are involved in putting together the factual information that forms your questionnaire response are present and participate at the verification. This includes being able to go directly into the computer system and actually trace everything you've reported in your questionnaire response right back to the original source documents. One other thing is Commerce also now is putting more focus on verifying what's called non-use. So if you report in your questionnaire that you didn't use a particular program, Commerce isn't just going to take your word for it. They're going to come to verification. They're going to say, you did not receive this assistance, you did not participate in this program. Can you show me that you didn't do that? And so proving a negative, something that you didn't do, is very challenging. And so it's very important for companies to think about this in advance of verification. I've had a lot of recent experiences where we've had a lot of difficulty satisfying Commerce that we didn't use a program. And so this is another thing to sort of strategically prepare for. So in summary, these are some of the recent trends that I've seen in the countervailing duty field. They're not very positive trends. In fact, they're very negative trends, and everybody needs to be very aware of this. And the way cases were done in the past, the way countervailing duty cases were done just several years ago, is no longer appropriate anymore. Everything you do in these cases has to be very carefully done, and you have to leave no stone unturned, because Commerce is really is looking to use its new adverse facts available authority. And again, I experienced what happened in the cold rolled and hot rolled investigations, and it was an awful experience. And I just would like to impart on you that how much Commerce is really looking to generate margins under the countervailing duty laws. Thank you.